And certainly the ramifications of the Holocaust are almost infinite. Over time, we hope that this program can at least comprehend most of the most important topics. Interestingly, the topic that's going to be addressed in part of tonight's talk, the Nuremberg Trials, represents an aspect of the Holocaust complex, or the complex of Holocaust-related issues that we have never dealt with before in this series of programs. And yet it's certainly among the most important. And one thing that makes it so important was the determination of the planners of the trials at Nuremberg to make sure to not merely state to the world the evils that had gone on in the name of Nazism during the Second World War, but to demonstrate to the world that these had in fact gone on, to prove it. And from their work, every student of the Holocaust has benefited. Everyone who's done meaningful research on the Holocaust goes back to the voluminous records, the documentation provided by those who built the cases against the Nazi defendants at the great war trials, especially those of 1945-46. So I guess as a historian, I have a particular sense of owing them a lot. And even today, by the way, one can go to the Valley Library and take a look at those big, fat volumes of records of the war crimes trials held under the International War Tribunal at Nuremberg in 45-46. Tonight's speaker, Thomas Brand, has a particular connection, I suppose we can say a double connection, with the themes that he's going to be addressing. First, through his father, who was the presiding judge at some of the most dramatic war crimes trials, those dealing with crimes against humanity in 1945-46. And second, because of Tom Brand's particular interest in international law and in the sort of issues relevant to Nuremberg and to war crimes trials since then. Nuremberg set many fine standards for such trials, which have been followed on since. Our speaker tonight had himself a long association with the law in army practice and private practice, and by the way, a linkage to Oregon from birth in Coos Bay, to this campus where he studied, where he was in an officer training corps back in 1944 toward the close of the Second World War. Then it was on to active duty, back into civilian life, study at Stanford, law degree from the University of Oregon in 1953, later a career as an assistant district attorney and assistant U.S. attorney, long-time career in private practice, and also as an instructor in business law at Willamette University. But always there was this passion of his in the field of international law, and an interest in the sort of issues confronted by, among others, his father at Nuremberg. So he has this double linkage to the themes that will be addressed tonight. And having said this, I welcome Tom Brand, our speaker for this evening.
By way of communication, one hand in the air means I have a question. Two hands means speak up, I can't hear you. And the double time is my wife sitting back there telling me that my time is up. Having said that, my theme tonight is one of personal responsibility. And to bring out the point, I refer to a particular case that came out of the war in Vietnam. I'm not talking about the My Lai incident, about which, if you haven't studied, you probably will someplace along the line. This is a question of individual responsibility. The accused, Sergeant Griffith, was convicted of acting jointly with others in the commission of an act of unpremeditated murder. At the time of the charged offense, he was a member of a platoon providing security for an engineer battalion in Bong Son, Vietnam. During his mission, the platoon had captured an unarmed male civilian who was brought to the command post, and a helicopter was ordered to take him out to headquarters. By the time the helicopter had gotten there, one of his soldiers was wounded. He therefore radioed his company commander for instructions. The helicopter had room for only one person. He was directed to use the helicopter for the benefit of taking the wounded soldier out. And when he asked what should be done with the prisoner, he was ordered to take the prisoner down the hill and execute him. And that's what he did. At the trial, he testified that he overheard the radio transmission and understood that the prisoner should be killed. He stated that the platoon leader had ordered a sergeant to take a prisoner down the hill and shoot him, and to return and tell the platoon leader when the assignment has been completed. He committed the act because he had been ordered to do so, he said, and believed the order to be legal because the platoon leader had once been relieved when a prisoner who had been securely tied had escaped during the night. The law officer instructed the military court as follows. Now, the general rule is that the acts of a subordinate done in good faith in compliance with his supposed duty or orders are justifiable. This justification does not exist, however, when those acts are manifestly beyond the scope of his authority, or the order is such that a man of ordinary sense and understanding would know it to be illegal. I tell you, as a matter of law, that if instructions or orders were received over that radio or were given to the suspect who was hapless to kill the suspect who was hapless there before him, such an order should have been manifestly known to be an illegal order. You are advised as a matter of law. Any such command, if in fact there was such a command, was an illegal order. Going on, a soldier or airman is not an automaton, but a reasoning agent who is under a duty to exercise judgment in obeying the orders of a superior officer, to the extent that where such orders are manifestly beyond the scope of the issuing officer's authority and are so palpably illegal on their face that a man of ordinary sense and understanding would know them to be illegal. Then the fact of obedience to the order of a superior officer will not protect a soldier for acts committed pursuant to such illegal orders. This is the law in regard to superior orders. Sergeant Griffin was convicted. He received a sentence of 10 years hard labor, reduction to private, and total forfeiture. On appeal, it was reduced to 7 years and later 2 years. 2 enlisted men who carried out the order along with Sergeant Griffin received respectively 12 months hard labor and 1 year hard later with a bad conduct discharge. In case you're curious about the officers who were involved, the company commander, the captain, and the platoon lieutenant were also court-martialed, and they were acquitted. The last time I talked about this, some old soldier from the audience said, yeah, they were probably promoted. Well, as a matter of fact, they were not promoted. Their defense was they refused, they did not admit giving the order. As a matter of fact, they denied giving the order or transmitting the order, respectively. Sergeant Griffin was the only one who testified that he heard the order given. And with the two officers, both of whom denied it, they were acquitted, obviously on a basis of 2 against 1. The significant thing, however, is that they were court-martialed. Whether they were actually properly convicted or not is another subject. The Uniform Field Manual 27-10, the Law of Land Warfare, American Military Doctrine, on the subject of superior orders, says, the fact that the law of war has been violated pursuant to an order of a superior authority, whether military or civil, does not deprive the act in question of its character of a war crime, nor does it constitute a defense in the trial of an accused individual unless he did not know and could not reasonably have been expected to know that the act ordered was unlawful. In all cases where the order is held not to constitute a defense to an allegation of war crime, the fact that the individual was acting pursuant to orders may be considered in mitigation of punishment. In considering the question whether a superior order constitutes a valid defense, the court shall take into consideration the fact that obedience to lawful military orders is the duty of every member of the armed forces, that the latter cannot be expected in condition of war discipline to weigh scrupulously the legal merits of the orders received, that certain rules of warfare may be controversial, or that an act otherwise amounting to a war crime may be done in obedience to orders conceived as a measure of reprisal. At the same time, it must be borne in mind that members of the armed forces are bound to obey only lawful orders. The fact that a person who committed an act which constitutes a war crime acted as the head of a state or as a responsible government official does not relieve him from responsibility for his act. The fact that domestic law does not impose a penalty for an act which constitutes a crime under international law does not relieve the person who committed the act from responsibility under international law. And that's basically the rule of the Nuremberg Trials and is applied today by the American military. And it can be a pretty tough situation in a given set of circumstances. But nevertheless, that is the law. We have been investigating fairly recently an incident that took place in Korea during the Korean War, so-called Nogunnery Incident. You may remember reading about it. That is to say, some civilians were allegedly slaughtered by American forces. And as far as I know, it's still under investigation. One of the little problems that has come up, one of the soldiers who allegedly testified about that was found not to have been there at all. He was simply quoting what the gossip was at the time. At the same time, or roughly the same time, there was another incident that hasn't received much publicity. And that is the fact that during the retreat, a bridge over another river was full of fleeing civilians, or at least fleeing people. And that bridge was destroyed in order to keep it out of the hands of the North Koreans. The defense for that is the defense or justification, if you will, of military necessity. The trouble with military necessity, of course, is that it proves too much. But there have been some interesting historical examples of military necessity, and one of them took place at the Battle of Agincourt, Henry V, in 1415. Henry was standing on top of a hill with his troops and saw that the French were about to break his line. He needed some reinforcements. He looked around, and the only reinforcing troops he could see were guarding a bunch of French prisoners. Since he needed the troops, he ordered the troops to slaughter the French prisoners. And he threw those troops into his line, and as you know, whether because of this or in spite of it, nevertheless, he won the Battle of Agincourt. The French have never forgiven Henry for this, but it's a pretty good example of a tough decision, a clear atrocity, but the defense of military necessity. That problem often comes up. But it wasn't a military necessity in the Griffin case. In 1474, Peter of Hagenbach, governor of Breisach, under Duke Charles of Burgundy, was captured by the forces of a coalition of Austria, the Swiss Leagues, France, and the towns of Upper Rhine. He was tried by an international tribunal, this was in 1474, for having trampled underfoot the laws of God and man and against natural law. He defended on the ground that he was obeying superior orders. The defense was denied, and he was executed. Now that's one side of the coin. The other side of the coin is nicely set forth by the Grand Prince Constantine, son of Tsar Paul I and grandson of Catherine the Great, the Tsarina of all the Russias. An officer, he said, is purely and simply a machine. Everything which is his superior commands of his subordinate must be carried out, even if it is an atrocity. Education, reasoning, and feelings of honor and justice are prejudicial to good discipline. An officer must never make use of his good sense or intelligence. The less he has of honor, the better he is. Now you can take your choice as to whether you like Constantine or the Peter of Hagenbach affair. As far as America is concerned, we looked in the words of Brigadier General Jacob H. Smith, the head of the forces in the Philippine insurrection, 1899 to 1902. Take no prisoners, kill and burn, he said. I don't care how many you kill and burn. He was court-martialed, reprimanded, and forced into early retirement by President Teddy Roosevelt. Phil Sheridan said to his instructed Colonel Randall S. Mackenzie for his campaign across the Mexican border against the Kickapoo Indians in 1873, I want you to be bold, enterprising, and at all times full of energy. When you begin, let it be a campaign of annihilation, obliteration, and complete destruction. He could have quoted Constantine on that. One can speculate that if the South had won the Civil War, they probably would have court-martialed General Sherman for atrocities committed by his troops in his march to the sea. It's a big help when your side wins the war. But nevertheless, as I've suggested already, here in America, we prosecute our own. And that is, I think, one reason for the United States not to be afraid of the International Court of Criminal Justice. The treaty provides that the country itself will have the first opportunity to try its own people before the proposed International Court of Criminal Justice takes over. And here in America, we try our own. Henry Wirtz, the commander of the Confederate prison in Andersonville, Georgia, was tried by a federal military commission for cruelty to prisoners in violation of the laws and customs of war. He pleaded the defense of superior orders. He was hanged. If you're down in Georgia sometime, drop in at Andersonville. It's an interesting place to look around. And you will get from some of the citizenry there a pretty good defense that Henry Wirz was railroaded, that he really couldn't have done anything more than he did to look after the North prisoners. But be that as it may, he was hanged. In the Leipzig trials following World War I, 12 Germans were prosecuted by Germans. Two of them, were convicted for machine gunning the survivors of the torpedoed hospital ship Landover Castle. The German court held that the subordinates were responsible because they knew or should have known that the order to machine gun the survivors was unlawful. The order does not free the accused of guilt if such an order is universally known to be against the law, said the German court. The Germans also tried a Captain Fryatt, who was captain of a British merchant marine vessel that rammed and sank a German sub. This was in July of 1916. At the time, apparently, Captain Fryatt was captain of an innocent-looking merchant vessel that had already stopped and then started up again and rammed the German sub before it could get away. There have been a lot of arguments about what to do in these circumstances. Colonel House, for example, President Wilson's advisor, said that Admiral Tirpitz deserved to be hanged at the end of a yardarm like any pirate of old. And that's one of the analogies of the Nuremberg Trials, that the Germans there were like the pirates of old, violators of international law, and could be hanged by whoever captured them. It's not the greatest analogy in the world, but at least it's one. After the First War, the Allies presented the Germans with a list of some 900 alleged war criminals. The Germans at Leipzig tried 12 and convicted 6. Article 228 of the Versailles Treaty stated that Germany recognized the right of Allied and associated powers to bring before military tribunals persons accused of offenses against the laws and customs of war. There was considerable talk as to what should be done with the Kaiser after the First War. And perhaps fortunately, since the Kaiser was hiding out in the Netherlands, they refused to give him up, and not much was done. As a matter of fact, the only trials that took place, which I know, were the 12 Leipzig trials by the Germans themselves. At Nuremberg, or before the Nuremberg trials themselves, there was considerable discussion among the Allies about what should be done with the Germans. I prefer to call them Nazis. Stalin recommended that about 100,000 of them should be executed. That a trial was simply to determine the sentence, because everybody knew that the Nazis were guilty. As a matter of fact, Churchill agreed with that proposition at one time, although not the 100,000. Churchill may have remembered the discussion that took place after Waterloo as to what should be done with Napoleon. The Prussians wanted Napoleon executed. The British were unwilling to do that, and as you know, they exiled him for the second time. Marshal Ney, on the other hand, the bravest of the brave, was tried and convicted by the French, and he was executed on December 7th, 1815. I simply like the date for obvious reasons. He was prosecuted for treason against the Bourbon government, which is one way of handling the problem, I suppose. But it wasn't for war crimes. It was for treason. Are the trials that took place in Nuremberg a dead issue? Well, not if you read, or read, an article that appeared in the Oregonian on April 4th of this year. In Ravensburg, Germany, one of Germany's accused Nazis, an 83-year-old former Nazi SS commander, was convicted of killing 7 Jewish prisoners during World War II. The prosecution had sought a life sentence, saying that he shot the inmates from a concentration camp in Nazi-occupied Czechoslovakia in 1945, at a time when he was a second lieutenant. He was sentenced to 12 years in prison. So Nuremberg is not dead. It's still alive, if not well. When they were discussing what should be done about the Nazis, and this was going on during the war when it became more and more likely that the Allies would win. And remembering what happened to Napoleon, and checking back on their own history, a bloody history on the part of all of the various countries involved, there were basically 3 choices. One was, kill them all. Or, to quote Stalin, at least the top 10,000. Churchill agreed with that to begin with. But the United States, from the very beginning, was opposed to it. That was option 1. Option 2, be forgiving. Let bygones be bygones, and let them all go free. And that was pretty hard to swallow, particularly right after the war. Our memories are still fresh. And anyway, there was a general feeling of justice. Justice should be done in some manner or other. And the third option was to set up a bunch of courts and decide who was most guilty, if you like, and what should be done to those people who are convicted. How much should we go for the doctrine of personal responsibility? And the choice was made, as you know, to try people on an individual basis. The IMT, the International Military Tribunal, which took place mostly in 1946 at Nuremberg, Germany, consisted of the top Nazis, and the judges, with the exception of the Russian judge, were civilians, French, British, and American. After that trial was over, the various zones proceeded on their own with regard to trials. In the American zone of Bavaria, there were 12 different trials of various Nazis consisting of military people, civilians of one kind or another, top guards in concentration camps, and in connection with Military Tribunal 3. The Chief Justice of Germany, Franz Schlegelberger, was the defendant in the so-called Justice Case, along with a number of other German lawyers, judges, judicial administrators, and so forth. They weren't charged with war crimes, they were charged with crimes against humanity. Some years ago, Abby Mann who was a well-known author, conferred with my parents while they were down in St. Petersburg, Florida, teaching, and wrote a script which became Judgment at Nuremberg, starring Spencer Tracy. If you haven't seen it, I recommend it. It's a very good movie. Not frightfully accurate. Marlene Dietrich was in the movie, and my mother was in Germany at the time, so there was no romantic connection between the judge and Marlene Dietrich or the other actress. I make the point because the subject is going to come up tomorrow with regard to sterilization. If you see the movie, you will be struck by Montgomery Clift, a very fine actor who was falling apart physically and mentally. He had a terrible time teaching him his lines. Many takes were necessary, and yet when you see the movie, you will see what a marvelous job he did. He played the role of a somewhat retarded German Jew who was sterilized by the Nazi regime. And the question that was never really resolved either in the movie or in the trial itself, and that is an actual incident that took place in the trial, as to whether he was sterilized because he was Jewish or because he was a little slow. But you're going to be discussing that subject tomorrow night, about the role of sterilization here in Oregon. And the Germans made that point, that sterilization was recognized for mental defectives, not necessarily in Oregon, although it was true, but also in the United States. The trials that took place in Nuremberg were 12 in number, and together with the International Military Tribunal, there were 209 either top or second level Nazis who were prosecuted at Nuremberg. Members of the High Command, members of the foreign ministries, members of the Krupp regime, I.G. Farman, Flick, the medical experimentation, the doctor's case. Groups of these people of these 12 groups were tried at Nuremberg in 47, 48, 49, 50, and so forth. If you see the movie, you will note that the movie says that it took place in Nuremberg in 1948, or that the trial took place in Nuremberg in 1948. Now that is not true. The trial itself, in which my father participated, took place in 1947. That is significant because one of the dramatic parts of the movie is that some of the American officers approached the American judges and said, "Take it easy on the Germans. We need them to fight the Russians because the Berlin crisis has just taken place." The Berlin crisis took place in 1948. The trial of Military Tribunal 3 was over by the end of 1947. That could have happened, and maybe it did in some of the later trials, but at least it didn't take place during the trial of Military Tribunal 3. What happened to them? Of the 209 who were indicted, 199 were tried, 36 death sentences, which included the IMT, 23 life sentences, 102 prison sentences, 38 were acquitted. One of the people who was acquitted in the justice case was the judge at Stuttgart. By reputation, one of the worst of the judges. But the Stuttgart courthouse was completely destroyed during the bombing, and there simply wasn't any evidence or insufficient evidence to support a conviction. Is that significant? Yes, I submit that it is significant. As to what happened to the people, the American authorities, along with the cooperation or at the request of the Germans after the war, began to ease things off. Oswald Rotog, one of the worst, who was the hanging judge of Nuremberg, received life imprisonment. He was released in 1956. Franz Schlegelberger, released provisionally for health reasons in 1950, was free for good by 1951. Within a comparatively short period of time, all of the defendants had been released, with the exception of Hess. And you may remember that the Russians were adamant that Hess should be kept on indefinitely. Altogether, American zone trials had sentenced 1,184 Germans, 450 of them to death. In the British zone, some 1,085 sentences, of which 240 were death sentences. The Soviet Union sentenced some 10,000 Nazis. What did they accomplish for the future? Having gone through the turmoil of deciding what should be done, we decided, with four allies, decided to have the trials to determine personal responsibility. And there were four basic reasons for the Nuremberg trials. One was, and the least important of them, was that some very bad things were done by some very bad people. And they should be forced to respond in some way for their actions, to take personal responsibility for what they did as individuals, and not as Germans, not even as Nazis, but as individuals for the most part. That's argument number one in favor of the Nuremberg trials. Secondly, it was designed to teach the Germans some of the rudiments of a fair trial. And for the most part, the Germans at the Nuremberg trials received fair trials. They were defended by attorneys of their own selection. They were appointed attorneys if they could not afford them. They were faced with their own documents. They were given the opportunity to plead in their own defense. One of the interesting things that took place before the trial, Military Tribunal 3 started, was when one of the lawyers, who was a defendant in the trial, was given a copy of the indictment sometime before the trial was to take place. And he immediately objected to the indictment because he thought that the trial had already taken place and that was the judgment of conviction. So much for a feeling of the learned member of the legal profession of Nazi Germany at the time. They did get a fair trial to the extent that justice can ever give a fair trial. Thirdly, and most importantly, or perhaps more important than the other two, was the fact that the Nazis were prosecuted and convicted mostly from their own documents. The record of the trial is replete with signed orders of sentencing, with violations of the law by their own documents. The fact that Hitler would call up somebody after having read about an article in the paper and order him convicted and executed, and he would be sentenced and executed solely on the basis of Hitler's say-so from the newspaper. And the judge that participated in that was one of the judges that got life imprisonment, although he didn't serve very much of it. The evidence is so conclusive, if you bother to read it, that nobody can complain. The Holocaust, that the atrocities, that the war crimes did not take place. It's there in black and white and can be read by anybody. The complete transcript of all 12 trials plus the IMT can be obtained by your university. It's available among other places at the Hoover Institution at Stanford, and the Library of Congress will also send you a copy if I'm not mistaken. So that's there, and the Nazis themselves convicted themselves out of their own words and out of their own documents. And that's why the judge at Stuttgart was not convicted. And the most important thing of all was what I chose to call personal responsibility. Pretty much, with the exceptions that I've noted earlier on, international law was considered to be the law between nations. Not so often was it applied to individuals, piracy being one example, and the other examples that I cited. But that's only a fairly small number. But in Nuremberg, and also at the Japanese war crimes trials, international law was applied to individuals, and people were made responsible for the consequences of their own acts. And that is very, very important, particularly for any ROTC members who might be in the audience. No longer can people hide behind the doctrine of obedience to a superior order. You, we, everybody are responsible for the consequences of our own acts. That's American doctrine. That's the doctrine of international law. And a fifth argument you can make in favor of the Nuremberg trials was that it had a tendency to discourage vigilante action. Certainly, revenge is part of the human past, present, probably future. But if people know that those who've done bad things will be punished, it removes the justification for taking personal vengeance. And that, I submit, is a good thing. Leave it up to the courts with the hope that a just result will take place. The idea of national sovereignty is based upon the idea, as far as crime is concerned, that the king can do no wrong because he rules in the name of God. There's some of that going on in the world today, is there not? That the king ruled by divine right. It's no longer true, if it ever was, that a person is responsible, whether he's an atheist, a Muslim, a Jew, a Christian. If American soldiers do the kind of thing that Nazi soldiers and others did, American soldiers deserve to be punished. And we punish our own. There are a lot of problems. When does war begin? What kind of a war is it? What's the difference, if any, between a just and an unjust war? And there isn't any. as far as international law is concerned. Mitigation of punishment, perhaps. But nevertheless, the law is there. It calls for a fine line on the part of the soldier to determine whether or not to obey an order sometimes. He's got to sit there and decide in times of stress, as the law officer said, whether to obey an order and be convicted in a national court or an American court-martial, or to disobey an order that is determined subsequently to be a lawful order and to be executed for failing to obey a lawful order. Granted, it can be a matter of degree. Oliver Wendell Holmes discussed this subject. The law is full of instances, he said, where a man's fate depends upon his estimating rightly, that is, as the jury subsequently estimates it, some matter of degree. If his judgment is wrong, not only may he incur a fine or short imprisonment, he may incur the penalty of death. And for a good many cases, that may very well be the problem that somebody is going to face, or some people are going to face. Now, with regard to the Holocaust, there had been quite a bit of talk or concern about the fact that America and Britain and France didn't, and the Pope, didn't do enough to prevent the Holocaust, or to at least speak out against it. And so the problem comes up, what do we do now? And let's assume that we get into a war with somebody. Right now, with regard to the Balkans, for example, we're applying international law. But let's suppose we get in a war with China over something or other. If we get in a war with China, and if we win, and if we occupy China, will we go after the present Chinese leaders for atrocities which we believe were committed in Tibet, in Tiananmen Square, and with the Falun Gong? And if you can imagine that, and hopefully it's not going to happen, will we be subject now, or will we be subject then, to criticism that we didn't do more to prevent those things from happening in 2001? And the answer to that is, I have the foggiest idea. The only thing we can do is keep track, and that's what we are doing. We're keeping track of what's going on in China. We're keeping track of what's going on in the Balkans. We're keeping track of what's going on in the Sudan. But whether we ever do much about it, except afterwards, that's a subject that I leave up to you. And with that, I can only say that trying to legalize war is very difficult. It's been tried before. We still keep trying. And it's a real tough problem, but an interesting one. And with that, thank you for listening.
Thank you very much, Tom. Are there any questions? There's been really many questions for Tom. Please.
You made a comment about Americans trying our own officers in instances of abuse. What about the DMI, your assessment of how we handle that involved in Vietnam War?
You mean the war itself?
No,
Oh, my line? Yeah. Well, frankly, I've got some sympathy with the lieutenant, but he was prosecuted, and he wasn't the only one. There were other atrocities committed by American troops. I mentioned one. There was a similar case that arose in Korea, and I believe that keeping track and making people responsible to the jury afterwards is the only way we will ever accomplish any kind of a law that hopefully will result in the knowledge of more people that if they sin, they will be held to answer. And in these cases, we still had judgment here, and if we would touch bloody instructions, which being taught return to plague the inventor, this even-handed justice commends the ingredients of our poison chalice to our own lips. We're back to personal responsibility, from my view. Now, if you're going to get into the problem of whether the war in Vietnam was a just war, I'd duck out on that.
Was there any consideration at the Nuremberg Trials, including German judges, on the bench? And the reason I ask that is because with the trials for war criminals in The Hague, one of the defenses which the Yugoslavian government presents is that Serbs should try their own war criminals, and that they're not going to get a fair trial. And there are also problems, of course, with sort of collective questions of collective guilt, but national responsibility. So was this ever a consideration at the Nuremberg?
Well, at Nuremberg, of course, there was no German state left. So it was a question of either the international community should step in or nothing would get done. But as I mentioned in the last one, the Germans themselves tried a number of Nazis, and as of a couple of weeks ago, we're still trying at least one. And also, as I mentioned, we believe that countries should prosecute their own. But having said that, a rump trial that took place in Sweden prosecuted the United States for war crimes committed in Vietnam. And as a matter of fact, a Serbian court fairly recently convicted President Clinton of war crimes. So if Bill's going to run around and make speeches, he'd better stay out of Serbia.
You traced the history of personal responsibility in Nuremberg. Is there anything new legally that the Nuremberg Trials brought up? Did they set any precedent?
Well, I tried to discuss this, of course, but mostly in the form of numbers. That is to say, a large number of people were prosecuted, more so than the occasional Henry V or Napoleon or whatever. But it's enough to scare, I think, the people who do these things in the world, the knowledge that they may very well be held to answer for what they've done. And on a broad scale, Nuremberg did that, and in my opinion, very properly so, if that's responsive.
Mr. Brand, as you closed, I thought, with a very provocative proposal at the end of your talk, suggesting that we might look differently now at the responsibility of the international community with regard to what they could have done to more preemptively stop the Holocaust crimes. I took it from your comment that it's easier to look on it in retrospect than it is in the current time. You would have a sense of personal feeling that the international community could have actually done anything about it in the early years when it became known that atrocities were occurring?
Yeah. Did everybody get the question? Could we have done something in the 30s and 40s? The answer is, frankly, I don't know. We weren't prepared to go to war over the Sudetenland or Czechoslovakia, and the United States wasn't prepared to go to war over Poland, and we weren't prepared to go to war over the atrocities in the large sense. And by that I mean there were lots of people who were subject to persecution by the Nazi regime other than the Jewish people. And our failure to act was not based on anti-Semitism. The problem was, what do you do? Gypsies, Catholics, Jehovah's Witnesses, French, Poles, Austrians, Czechs, all of the people who suffered from atrocious conduct on the part of the Nazis suffered. And when do you step in on that kind of thing, and when do you not? It's way beyond my feeling, even with the benefit of 20/20 hindsight. It's a little like trying to decide whether the Blazers made a mistake a couple of nights ago and what should have been done. Being facetious about it.
But is there any grounds for international action? I mean, I'm trying to sort out, and I don't know anything about law, but trying to sort out, is there any grounds for international action at all?
Certainly, we're doing it now. We've got trials going on in The Hague right now. It's true, in a sense, that that's victor's justice, if you want to call it that. But there's nothing new about victor's justice. If two people hold up a bank and one of them is captured and the other escapes, you don't let the one you've captured go simply because you can't capture the other, because you can't find the other guy. The mere fact that the Russians probably killed more of their own people than the Nazis did doesn't mean that the Nazis should escape. What could we have done about the Russians or communists? We didn't do much, if anything. And what should we have done? Go to war? And if so, when? So I don't know. But there are some people, mostly lawyers, who are striving to deal with these difficult problems. And we're not willing to leave it all up to our God or gods. In these cases, we still have judgment here. And that's as far as I can go with this.
Well, Tom, I'm going to take advantage of the moderator's prerogative and ask a question. Back in 1998, during the Holocaust Memorial, we had a talk by a fine scholar named David Kitterman, who dealt with what happened to Germans in uniform refused orders to kill civilians, and there actually were some,
yes,
not very many of them.
Yes.
And he noted that in a number of cases, their defense, those of them who were in fact called to account for their refusal to kill civilians, their defense was often that under military law, they were not expected to kill unarmed, defenseless civilians, and they could resist that order. And they were not, in fact, successfully prosecuted, and indeed, then they were not shot, they were not sent to concentration camps. Most of them continued their military careers, and some of them were actually promoted subsequently. It does raise the whole question of does the defense of only following orders ever work? Is it ever justified? under a regime that is perhaps so harsh that it will in fact inflict punishment on soldiers who refuse to obey orders to kill. In this case,
Okay, 2 points, I think. One is that my understanding is that the members of the SS, the Einsatzgruppe and some others, who were responsible for the guards in the concentration camps where a lot of these things took place. Some of them refused to do that, to proceed against the victims in the concentration camps. And some of them were not prosecuted. And the military people were not prosecuted. And I agree with that. The alternative, however, was you either stay here and do this job or you go to the Eastern Front. And some of them chose the Eastern Front. And for a good many of them, they never came back. Now, I think Mr. Hobson has something to say about this choice. But that's true. They had a choice. Okay?
Well, if I could follow up with your comment, though, I mean, what's very disturbing, though, was your initial example of the soldier in Vietnam and the language of the American, I assume, is martial law statute. Specifically, the use of the word illegality regarding an order. I mean, I thought, maybe I'm wrong, one of the basic tenets of criminal law is that guilt is a legal outcome. So in a sense, you're determining an illegal act at the end of a trial. But asking a fellow on the spot to determine that something is illegal without the full set of facts is an extremely tall order. So I guess I'll put the question to you this way. Step back into your lawyerly shoes. You're now the defense attorney for that, I forget what he was, a sergeant. How are you going to make his defense? I mean, given that, you begin with a close reading of the statute, what constitutes the crime? What's the mens rea, so to speak? I mean, how are you going to defend that fellow?
Well, that's easy. If I get paid enough, I'll be glad to defend him.
Well, I know you'll defend him, but how will you? I mean, what are the points that you would attack in his defense?
Well, I would probably use the defense of superior orders, and it would fail. I guess I could argue that he was temporarily insane. But I think I would lose. And you're talking to a lawyer who has lost on various occasions. And it falls back on Oliver Wendell Holmes. Being able to determine rightly, that is, as the jury subsequently determines it, some matter of degree. And it can be pretty rough. But I think people are better off knowing the problem than going into it blindly. When I was in the military as an enlisted man at Camp Roberts as an infantry private, it was obey, obey, obey. Only once do I recall ever having a JAG officer say, but only obey legal orders. As I recall, that was kind of scary, and it still is. But hey, that's real life, too. Now, if I take a gun and I hold it to your head and say, shoot that person over there, you cannot defend on the ground of self-defense. Mitigation, yes. But you're not justified shooting a guy over there simply because I've got a gun to your head.
Okay, well, I'm just pointing to a circularity.
Sure.
At the end of it, we say guilty or not guilty, illegal or legal act at the end. It's a legal outcome of a proceeding. But now you're saying that during the commission of the act, one is supposed to perceive illegality and legality from the less than the totality of circumstances, and you should have known that it was illegal. Well, I mean, you have to go to the language of the statute and really parse the statute to see what they mean by legal and illegal. And I'm sure you'd have all kinds of case lines either way. I mean, that's how I would start to defend them. And then, of course, look at the circumstances. You know, but there's a profound circularity in that kind of reasoning.
Happens every day, sir.
Last question.
I had a question. Where do you draw the line between, say, an order for a whole battalion to attack an enemy position and kill that enemy, and, say, a small group to attack an enemy or commit some sort of atrocity? Where does war become a crime against humanity, and how do you draw the line?
Fair question, impossible answer. There's a difference, I submit, between, well, let's cite one example. A Japanese private going through a town in China, being disturbed by the crying of a Chinese baby, picking up the baby and bashing its head against a stone wall. Okay? Some recorded instances of that, see the rape of Nanking and so forth and so on. And the same Japanese military plane flying over that same village and dropping some bombs and killing a large number of people. The baby's just as dead, the people are just as dead. But if you can't draw the distinction between the one private and the baby and the pilot at 10,000 feet, you better learn how to draw that distinction, because it exists. But it's not easy to quantify. War inherently is, I suppose, illegal. And it's certainly very difficult to set down hard and fast rules about the conduct of war. Some rules are long-standing. Don't poison the enemy's wells. Disarmament has been tried. The earliest disarmament convention that I ever heard of was by that great scholar and historian Bob Newhart, who talks about an attempt on the part of our cave-dwelling forebears to get together and bomb and ban the spear. And people have been trying to do something like that for a long time. That's war. If it weren't war, we'd call it party.